Hi, everyone. Thank you for joining us today for Constangy's webinar, ADA and FMLA in the Real World, Avoiding Common Compliance Traps. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters may not be able to address all of your questions during this session, but we encourage you to reach out following the presentation. Their contact information will be included in our post-webinar follow-up email. This program is approved for SHRM and HRCI credits. We will be sharing those codes at the end of this presentation, so please stick around in order to get them. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Darrick McDuffie and Kristin Titley.
Hello, everyone, and thank you for joining our program today. I am here with Kristin Titley, and our program is ADA and FMLA in the real world, avoiding common compliance traps. I am the managing partner of the Atlanta office of Constangy Brooks Smith and Profit LLP, and I'm also co-chair of our firm's Trade Secrets and Unfair Business Practices group. And generally, my practice includes FLSA litigation advice and counsel regarding confidentiality, non-compete, non-solicitation agreements, and the entire range of discrimination, harassment, and retaliation laws. And I regularly practice in both state and federal courts here in Atlanta and nationwide. And I also represent clients in arbitrations involving allegations of discrimination, harassment, and retaliation. And with that, I'll turn it over to Kristin to introduce herself.
Hi, everyone. Thanks for the introduction, Darrick. My name is Kristin Titley. I'm an associate in Constangy's Nashville office. I've been practicing law for coming up on 11 years now. Earlier in my career, I spent a few years outside of private practice. But since moving into private practice, my work has focused exclusively on management side employment law. A large part of my practice includes defending employers in litigation involving workplace statutes like ADA and FMLA, which is what we're here to talk about today. And of course, other leave-related laws, as well as discrimination, retaliation claims, FLSA, I regularly handle all of these types of cases from the administrative stage through litigation. In addition to litigation, I also spend a significant amount of time in advising employers on day-to-day compliance issues, things like navigating accommodation requests, managing leave situations, and helping employers avoid the types of compliance traps we'll be talking about today. Think that sums it up, Darrick?
All right. Thank you, Kristin. So for our program today, I'll be leading off discussing the FMLA, and Kristin will follow discussing the ADA. As it relates to the FMLA, I'll discuss what is it and when does it apply. We'll talk about the definitions of serious health condition under the FMLA. We'll talk about how FMLA lawsuits can arise. A spoiler alert, interference and retaliation. And we'll talk about some common compliance traps. And a lot of this will be common sense, but I believe it's always worthwhile to revisit these common sense issues. With that, Kristin, I'll let you quickly highlight your topics.
Great. Thank you, Darrick. As Darrick mentioned, I'm going to focus on the ADA portion of the presentation today. So we will start with just a brief overview of what the ADA is, when it applies, including which employers and which employees are covered. Then we'll look at how the law actually defines disability, how that's different than how the FMLA defines serious health condition. From there, we'll talk about an area that often creates confusion in practice, how the ADA and FMLA interact, particularly when employees have, exhausted FMLA leave, but may still have rights under the ADA. And finally, we'll walk through some common compliance traps that we frequently see employers run into when dealing with ADA issues in the workplace.
Thank you, Kristin. So to get started, our FMLA overview, some basic rules. We're dealing with 12 months of employment, 1,250 hours in the preceding 12 months, 50 employees within 75 miles. And obviously, we're discussing leave for qualifying family and medical reasons. And of course, we all know the 50 employee threshold and 20 or more work weeks. So, what are the qualifying reasons an employee can take FMLA leave? You have birth of a child or placement of a child for adoption or foster care, care for a close relative with a serious health condition, the employee's own serious health condition. And then separately, you have military issues um, due to federal call up for contingency operations. That could be for a spouse, parent, or child. You have leave to care for a relative or next of kin of a military service member with a serious injury or illness, and we're talking 26 weeks. It's always important to remember there is the distinction in how this plays out in the military context as opposed to otherwise. Let's talk a little bit more about the birth of a child. This is one of the most common reasons for FMLA leave. So let's look at how it works. First, everyone is treated the same, regardless of gender. You must finish the leave within 12 months after birth, and we're dealing with only continuous leave. Intermittent leave would require both the employee and employer to approve using intermittent leave. And for those workplace romances that result in coworkers getting married, the FMLA will apply differently. For today, we're focused on leave laws, everybody, so we'll ignore the potential sexual harassment issues involved in workplace romances and get on with the FMLA part of that. Um, so back to the FMLA. Married couples are limited to a combined total of 12 weeks during a 12-month period. So if, again, you and your spouse work at the same company, that's how it will work. If it's for a sick child or the other spouse or your own serious health condition, in that instance, you each have your own 12 weeks. Next, what is a serious health condition? Incapacity, treatment, incapacity due to pregnancy and prenatal care, any chronic serious health condition, or long-term or permanent incapacity due to a condition where treatment may not be effective. We're moving on. See if I skip the slide. Continuing with serious health conditions. We're talking in this instance about inpatient care or continuing treatment. Focusing more on inpatient care, what will qualify an overnight stay in a hospital, hospice, or a residential medical care facility, or any period of incapacity, and any later related treatment following any of these types of overnight stays. Continuing treatment. Continuing treatment also qualifies if the employee is treated by a healthcare provider within 7 days of the first day of incapacity, and either prescribed a course of treatment by a healthcare provider or has at least one other visit with a healthcare provider within 30 days of the first day of incapacity. Next, what can treatment include? Examinations. Um, First, to determine whether a serious health condition even exists and how to treat it, and then a regimen of continuing treatment, prescription for medication or therapy. And what does treatment include? Routine physicals. I'm sorry, what does it not include? Routine physicals, eye examinations, or dental examinations. And if all you have is at-home treatment by itself, that is not enough.
Quick question on that, Darrick, before we move on past serious health condition. Something that I see employers get confused about a lot is the difference between serious health condition and a disability under the ADA.
Mhm.
Can you talk for just a second about the distinction between those two, how broad serious health condition is?
Absolutely. And I know you'll get into more detail about the ADA side of this, but generally speaking, on the FMLA side, a serious health condition is defined broader than a disability is defined under the ADA. So employees shouldn't fall into the trap of thinking that if you've determined that someone doesn't have a disability, then you don't have to worry about FMLA, and vice versa. Simply because someone is qualified for FMLA doesn't mean you have, necessarily speaking, an ADA issue.
Thanks, Darrick.
So, what leave is allowed? Up to 12 work weeks of leave in a 12-month period for any reason except military caregiver leave. That's different. For that, you got 26 work weeks for military caregiver leave. That's again during a 12-month period. Employees can take the leave all at once or when it's needed in separate blocks or by reducing the time they work each day or week. So there is flexibility there. And intermittent or reduced leave is also available for military family reasons. And we will move on. So, just a bit about what protective job leave actually means in the real world. Um, the idea is your job is protected, but you're not required to be paid. You also have protection for your health insurance plan because that should continue during your FMLA leave on the same terms as before the FMLA leave. And it goes back into effect upon return after FMLA leave in the same manner as it was before FMLA leave. Um, it can be used at the same time as paid leave. So even though FMLA is unpaid, it can be used at the same time as paid leave. You can require it as an employer to be used during the use of paid leave. Um, the idea is when it comes to knowing whether an employee needs FMLA, it's not a very high bar. My advice to clients is to err on the side of caution because you're only required to be on notice or have enough information to know that the leave might be covered by the FMLA. So once you know that, provide notice and you will fulfill the notice requirement. Um, on the employee side, employees must provide notice as soon as possible that they need FMLA leave. And just to let you know, we will try to save time at the end to answer questions. If we don't have time to answer questions at the end, we'll answer them and get those out to the individuals who've asked the questions. So thank you for the questions. Keep them coming. Next, how should FMLA be scheduled? We talked about this briefly just a moment ago. Employees have to give notice, and the rule is to give notice 30 days in advance if possible. If that's not possible, then employees have to give notice as soon as practical. Um, my advice to clients is to have a clear policy in your handbook relating to the request for FMLA and how it should be made, because employees will be required to follow that policy. Next, when does intermittent and reduced schedule leave come into play? First, it must be medically necessary, involving planned or anticipated medical treatment of, again, a serious health condition, or recovery from a serious health condition, or last, to care for someone in the family with a serious health condition. And we talked about this a little while ago. What is a serious health condition under the FMLA? And remember this when we get to Kristin's portion of the presentation where she'll discuss what um, is a disability under the ADA. But under the FMLA, a serious health condition is any illness, injury, impairment, or physical or mental condition that involves either inpatient care in a hospital, hospice, or a residential medical care facility, or continuing treatment by a healthcare provider. One of the clues, if you will, in noticing an employee's need for FMLA is if the employee is taking a lot of doctor's visits and informing you of the need to take those doctor visits. You might need to consider whether those visits and the time away is for an FMLA qualifying reason. Next, what is considered continuing treatment? So when we're talking about any period of incapacity, we're talking about inability to do work, attend school, or perform other regular daily activities due to treatment or recovery. So for more than 3 consecutive calendar days and treatment 2 or more times by a healthcare provider, or treatment by a healthcare provider on at least one occasion, then a regimen of continued treatment. We're talking prescription drugs, that sort of thing. And then continued treatment does not include certain things such as um, resting, drinking fluids, and just those basic things that obviously would not qualify. All right, now that we've talked a bit about how this works, let's talk about lawsuits. Um, First, we have interference claims under the FMLA. One very important point there to remember is that intent is not required. Intent is irrelevant. So what does an employee have to show in an interference claim? The employee must show that the employee gave notice of need for leave. And if you remember from earlier in my presentation, that bar might be low. So the idea is at some point, if you are given enough information to know that the person needs FMLA leave, that will be enough. The employee was entitled to a benefit under the FMLA, and the employee was denied that benefit. And again, those are the only things that are needed. Intent is not an element. Next, we have retaliation claims. Again, intent is not required. Intent is irrelevant. This is similar to other discrimination lawsuits. In a retaliation suit under the FMLA, the employee has to show that he or she engaged in statutorily protected activity, suffered an adverse employment action, and the decision was causally related to that protected activity. And I'll answer one question that I see in the chat. Can you elaborate on what you mean when you state intent is not relevant? Let's look at, let's go back. In an interference claim, um, if the employee is entitled to FMLA leave and that is denied, it doesn't matter why it was denied. It doesn't matter the state of mind of the employer in denying it. If the employer doesn't provide notice of the employee's right to FMLA, it doesn't matter if it was a mistake or if someone was on vacation and wasn't available to provide the notice. Um, the intent doesn't matter. You don't have to prove as an employee that the reason you weren't provided notice was because your employer didn't want to provide you with FMLA leave. If you are denied FMLA leave, you don't have to prove that your employee denied it because they intended to deny you of a right to which you were entitled under the law. The only question is whether you were legally entitled to it and were denied. The reason for the denial is irrelevant. Now, just to catch back up, we have our first pop quiz slash fact scenario. Your employee, Heathcliff, and his wife, Claire, have raised their stepdaughter, Olivia, since she was 3 years old. Olivia's stepmother, Denise, Heathcliff's daughter, had legal custody of Olivia, but only occasionally lived with them too. I may be showing my age with this fact scenario for any of those who are picking up on the names. When Olivia was 21 years old, she became pregnant. Olivia gave birth to a healthy girl, but during the delivery, Olivia had a stroke, remaining hospitalized for months. Heathcliff requests leave for care for both Olivia and the new baby. Is this FMLA qualifying? I'll give everybody a moment to consider. I have some answers coming in. I won't reveal anyone's answers by name, but we have quite a few coming in. And almost everyone got it right. Yes. You might be wondering why. So this next slide will help. The key is that the definition of whether someone is an employee's child is relatively broad. Biological, adopted, or foster child, stepchild, legal ward, or child of a person standing in loco parentis, who is either under the age of 18 or age 18 or older and incapable of self-care because of a mental or physical disability at the time the FMLA leave is to commence. So keep in mind that we're not talking just strictly biological children when we're referring to an employee's right to take FMLA leave relating to a child. And what about this strange word, loco parentis? What does this mean? Essentially, people with day-to-day responsibilities to care for and financially support a child, or in the case of an employee who had such responsibility for the employee when the employee was a child. Again, a biological relationship isn't necessary. Even a legal relationship isn't necessary. And if the FMLA applied long, long, long ago, some would say you could qualify for FMLA for taking care of any child in your neighborhood. Again, dating myself with that one. The key is someone who's standing in a position equivalent to being a parent. Now, obviously, how can you know if someone is in loco parentis status? The answer is the employee has the obligation to notify the employer of the relationship. And we have here our first real case fact scenario, Martinez Patterson versus AT&T Services. There, the employee saw FMLA leave to care for a sibling and was informed this was not a basis for seeking FMLA leave because siblings were not covered. The employee was subsequently terminated. In challenging the termination, the employee asserted an FMLA interference claim, arguing she stood in loco parentis to her sibling. In the end, because the employee never notified the employer at the time of the FMLA request of the loco parentis status, her FMLA interference claim was dismissed. What I will say about that case is documentation is important because you'll have disputed issues of material fact if these conversations about FMLA are only done face to face rather than being documented. So always, always, always document because that's the only way you can prove in an instance like this that when the leave was requested, you were not notified of the loco parentis status. All right, I'm going to date myself again for everybody who's on the call. This slide is the Beyonce rule. If you want FMLA, then you better put a ring on it. I'll wait until everybody stops laughing and can get ready for the rest of this. Proctor versus Riley Industries, Inc. The employee was engaged to a woman who was pregnant with his child. He sought FMLA leave to attend the prenatal appointments with his fiance. Lo and behold, his request was denied. The court held that the employee was not a spouse as defined by the FMLA, was not a parent as defined by the FMLA because the child was not yet born. Just taking a look to see if there are any questions we can answer now without getting off track on time. All right, we'll just keep going and I'll keep glancing at those questions as we keep going. And I apologize, the lights in my office go off when I don't move for a long time. All right, we're on our next slide. Keep in mind that the FMLA also doesn't protect in-laws or siblings. We had the fact scenario earlier about a sibling, and the only reason the employee was claiming FMLA leave was because of the in locus parentis status, but the employee hadn't informed the employer of that. So remember, in-laws, siblings, not covered. Now let's talk about FMLA documentation, i.e. certification forms. Um, if the employer has reason to doubt a certification that's provided, it's okay to ask for a second opinion. It will be at the employer's cost, Um, um, but the employer can also select the provider for that second opinion. Now, there are some rules to keep in mind. Generally speaking, don't do it more often than once within 30 days. Um, um, and in connection with an absence, unless minimum duration of leave is more than 30 days. Then you wait until it expires. You can request it every 6 months as long as it's in connection with an absence. And when you're talking about these opinions, in this instance, no second or third opinions on the recertification itself. The first certification, you get the recertifications, but the recertification, no second or third opinions. And we'll move a little quickly so we can keep on time. You can request recertification early in these instances. If there's a request for an extension of leave or circumstances change significantly, and there's some examples there for you, or if you receive some information that casts doubt on the continuing validity of the certification. The employer can also give the healthcare provider a record of the employee's absence pattern and ask if it's consistent with the health condition. And if the employee doesn't comply with this, that could be a basis to deny leave. Um, and we're back to another real world fact pattern. I know it's hard to believe, but some employees do take advantage of leave laws. So let's take a look at how that can play out. Davis Jackson versus American Airlines. No ADA discrimination or FMLA retaliation claim where the employee was terminated based on suspected leave abuse, fraudulent leave. And the employee was not protected by the FMLA when taking leave for depression, but the FMLA leave was only approved for migraines. We have another example, LaBelle versus Cleveland Cliffs, Inc. Employee approved for intermittent FMLA for medical appointments and flare-ups of a joint condition. Employer noticed a suspicious pattern of FMLA days and consecutive vacation days. We have March Madness coming up, so if any of you see a spike in your FMLA employees taking days off, might want to take a look at that. That's not legal advice, by the way. That's a joke, as we say. Employer hired a private investigator who filmed the employee playing golf. The employee's termination was upheld and no violation found. Next, does vacationing while on FMLA leave constitute leave abuse? Not necessarily. So in the Prado versus Mass Water Resource Authority, the employee was approved for FMLA leave for foot surgery and associated recovery. The employee tried to return to work early, but could not do so without a doctor's note and couldn't get one for a few weeks. He went on what was a previously scheduled trip to Mexico in the last 1 to 2 weeks of his leave. And during the trip, he limited his activity to be consistent with his medical restrictions. The employee terminated, the employee was terminated by the employer for leave abuse, and the employee filed suit. And I wanted to put the dollar amount in here because it's a significant recovery. The employee was awarded about 1.3 million in damages for FMLA retaliation. So not bad, being paid $1.3 million for taking a trip to Mexico. Another example, or two examples. If employees are on leave to do a specific thing, for example, in this case, to care for their parents, they have to care for their parents. In the first case, Scruggs versus Carrier Corporation, the employee was observed not leaving his house for the day that he was on leave to take his mother to a doctor's appointment, and the court found there was no right to reinstatement. If you're off work for that day to take your mother to a doctor's appointment and you don't, then that's leave abuse. Stoneham versus U.S. Airways Inc. This is a closer call, but an employee was absent from work for a full day again, to care for his mother, but only spent a few minutes with his mother. And that was also found to be a lawful termination of employment. Next, it's always helpful to have a call-in policy. I will talk a lot about that. Just make sure that you have the right people fielding those calls, more than one person. Make sure everything is properly documented. The next slide is a lot of common sense, and common sense is always important. So don't forget about the common sense when applying the law. Communication, set expectations, review the policy with your employee. Um, Also remember this is a two-way street. The employer can ask the employee to schedule things at a time that's more convenient for the job. We have another fact pattern here, and I'll move quickly. Jack's wife is pregnant and due later this year. He has to have knee surgery. He says he doesn't want to count that time because he wants to use all of his FMLA when his daughter is born. What do you do? I'll give you just 30 seconds. All right. All the right answers are coming in. Yes, you must count the 2 weeks to undergo knee surgery against his FMLA leave. And our last fact pattern is one I like because it shows why documentation is so important. Clodfelder versus Miami-Dade County. The plaintiff failed to establish an FMLA interference claim where she repeatedly indicated she did not want to return to the department, indicated that she was going to be looking for another position, and when the department head indicated it was his understanding that she did not intend to return from FMLA leave, she did not challenge or dispute his understanding. What I left out of all of that so that I could just tell you is that all of that was documented. Without that being documented, you end up in disputed issues of fact when you're facing a lawsuit. And I'll close out my portion of the presentation with just some more practical advice. Make sure that you undergo good training for all your managers, HR staff relating to FMLA and ADA issues, and be mindful about how things that are said in the workplace can impact a lawsuit if there's ever a lawsuit down the road. And these quotes that I have here are from a collection of actual cases. So you don't want to say things about individuals who are on FMLA leave, or when Kristin gets to her part, dealing with disabilities, um, such as you've taken too many days off. That's a bit on the nose. You know you've missed a lot of work. Not a good time to take leave. Need a backup plan. You need to get ready to fire him. Your continued unpaid time away from the workplace compromises the quality of care. So, just some practical advice, just be mindful of the way you speak about individuals' leave and requests for leave, because that could end up being evidence in a lawsuit down the road. With that, I'll turn it over to Kristin.
Thanks so much, Darrick. As Darrick said, we're now going to shift gears, talk a little bit more about the Americans with Disabilities Act, or as we pretty much always call it, the ADA. So while FMLA provides job protected leave, the ADA is fundamentally an anti-discrimination statute. It prohibits discrimination against qualified individuals with disabilities and requires employers to provide reasonable accommodations so those individuals can perform their jobs. Most, if not all of you, are at least generally familiar with the ADA and the requirement that employers provide reasonable accommodations. In practice, however, this is often where employers get tripped up because ADA obligations don't always end when FMLA leave ends. The two laws frequently interact, and failing to recognize that overlap is one of the most common compliance mistakes we see. Okay, so let's start with the basics of ADA coverage. First, employer coverage. ADA applies, I'm still on there we go, that one, yep.
Sorry.
That's okay. The ADA applies to employers with 15 or more employees who worked at least 20 calendar weeks in the current or preceding year. Then you have employee eligibility. The ADA protects qualified applicants and employees with disabilities. Finally, the purpose of the statute. The ADA prohibits disability discrimination and retaliation, and it requires employers to provide reasonable accommodations. Unless doing so would create an undue hardship on the business. One important point for employers is that accommodations can include leave from work, which is where the ADA often overlaps with the FMLA. Okay, moving on to practice tips. A few practical points about how the courts and the EEOC analyze accommodations. So first, you have the concept of undue hardship. This means that an accommodation would be too difficult or too expensive considering the employees or employer's size, financial resources, and operational needs. Very importantly, though, cost alone is not enough to refuse an accommodation. Second, the employer does not have to provide the employee's preferred accommodation. It's called the interactive process for a reason. The obligation is to provide an effective accommodation. If more than one option works, the employer generally can choose which one to implement. It doesn't have to be the one that the employee necessarily prefers if both of them work equally. Another important point is leave policies. Employees with disabilities must have access to leave on the same basis as similarly situated employees. And finally, employers should always remember that state laws can impose additional requirements, which may be more protective than federal law. Obviously, we can't go into each and every one of the state laws here right now today. That would take us until tomorrow, probably next week. But just keep that in mind, whatever state you're in, there may be some additional requirements. As I keep mentioning, one area where employers frequently make mistakes involves leave as an accommodation. Under the ADA, unpaid leave may be a reasonable accommodation, even in situations where the employee would not otherwise be eligible for leave. You're probably saying, how does that apply with FMLA? How is that different? FMLA is unpaid leave, right? So this comes up often where, an employee has exhausted their FMLA leave. They've taken their 12 weeks. They've worked there less than a year or less than the 1,250 hours that they're required to work. They don't qualify for FMLA leave. However, you still need to consider whether they qualify for unpaid leave as a reasonable accommodation under the ADA. So, for example, leave may still be required even if the employer does not normally offer leave as a benefit, the employee is not eligible under company policies, or the employee has already exhausted other leave, such as FMLA leave, workers' compensation leave. That is why it is so critical to engage in the interactive process with the employee before just straight denying leave. Another common compliance issue that I'll talk a little bit more about later, but I'll go ahead and mention quickly here are what we call 100% healed policies. Basically, policies that require employees to return with no restrictions whatsoever. Those policies can violate the ADA if the employee could perform the job with a reasonable accommodation. So, looking at the definition of disability, what actually qualifies as a disability under the ADA? The statute defines disability in three different ways. First, an individual may have a physical or mental impairment that substantially limits a major life activity. Second, the individual may have a record of such an impairment. And third, the person may be regarded as having an impairment, even if the impairment does not actually limit them in the way the employer believes. We refer to those second two as record of and regarded as. We don't see those as frequent. I see them in litigation a lot, but not necessarily in day-to-day practice. What you are typically looking at is that first definition, physical or mental impairment that substantially limits a major life activity. Because of the amendments to the ADA back in 2008, courts now interpret disability quite broadly. So the focus of most litigation tends to be less about whether a disability actually exists. So often we almost skip over that, admit that yes, the person had a disability, but here is, why they did not mess up. It was not related to the definition of disability necessarily. More about how the employer handled the accommodation process. That's where we see the most issues. So our advice there is it's better to err on the side of caution. If you have any doubt as to whether someone qualifies as having a disability, try to provide the accommodation, especially if it's a simple one, you're able to provide the accommodation, better to err on the side of caution. So as we mentioned again earlier, comparing the ADA versus FMLA, serious health condition under FMLA is actually quite a bit broader than the ADA definition of disability. So that means that many conditions that qualify for FMLA leave may not qualify as a disability under the ADA. So, for example, certain, temporary conditions in particular, like pregnancy, hernias, broken bones, may qualify as a serious health condition for FMLA purposes, but do not substantially limit a major life activity to qualify for a disability under the ADA. On the other hand, some conditions, cancer, stroke, may qualify under both statutes. Understanding this difference is critical because the legal obligations under the two laws are not identical. Okay. Now getting into kind of the heart of the matter, failure to accommodate. Most ADA lawsuits involve claims that an employer failed to provide a reasonable accommodation. To prove that claim, the employee must show three things. First, that the employee has a disability under the ADA. Like I mentioned earlier, it's defined quite broadly. Second, that the employee was qualified for the job, meaning they could perform the essential functions with or without a reasonable accommodation. Basically, if you could have provided them an accommodation, they still could have done all of the essential functions of their job. And third, that the employer failed to give that reasonable accommodation. Notice that this analysis focuses heavily on the accommodation process, which is why documentation and communication are so important. I don't know if I've mentioned it yet, but throughout this whole process, documenting each step, what the employee requested as the reasonable accommodation, when you had the interactive process meeting, maybe what accommodations you offered instead, documenting, keeping track, follow-up emails, things like that that keep track of what's happening during this interactive process. Okay. Another important point with ADA accommodation claim is that intent is not required. In other words, an employer can violate the ADA even if they acted in good faith. The saying often goes, no good deed goes unpunished. One of the common ways employers create liability is failing to engage in that interactive process. If an employer simply denies an accommodation request without discussing alternatives or gathering information, that alone can create legal exposure. So what does the interactive process actually look like? It is essentially a good faith dialogue between the employer and the employee. So the employer should meet with the employee, document that, identify the employee's limitation, maybe document that as well. Discuss potential accommodations, evaluate whether those accommodations are effective, and then implement a reasonable accommodation where appropriate. The key point is that this process should be collaborative, not one-sided. And of course, what should the employer be doing throughout that entire process? Right, documenting it. Interactive process does also have some important boundaries. Employers are only required to accommodate essential job functions. That's why having clear written job descriptions can be extremely helpful. Job descriptions are for so much more than telling an applicant, what they are going to be doing. Clear job descriptions that describe an employee's essential functions can become critical in litigation. They serve as evidence of what their essential duties actually are. Employers must also maintain a good faith effort throughout the process. Of course, at the same time, employees also have obligations. They do not have to specify or identify, a specific accommodation, but they do need to communicate enough information about their limitations so that the employer can understand the problem and evaluate possible solutions. On the other hand, if they provide a very specific, accommodation, perhaps a different keyboard that they need or very specific, costly, but there is something else that can meet the requirements, that can also be part of the interactive process. The term reasonable accommodation, what is a reasonable accommodation? It covers a wide range of possibilities. It can include things like making facilities accessible, restructuring job duties, modifying work schedules, reassigning an employee to a vacant position, or modifying equipment or workplace policies. Key principle across all of those is that the accommodation must allow the employee to perform the essential functions of their job. And less doing so, of course, would create an undue hardship. Okay, first fact scenario here. And I will try and make these quick. I know that we are coming up quickly on our time. So let's walk through a quick example. So imagine an employee named Sarah who works as a customer service representative. She provides a doctor's note stating that she has multiple sclerosis, and she requests to work from home 3 days per week. The company denies the request. They have a policy. All employees must work in the office. That's the policy. They deny it. Is that an ADA violation? I'll give like 15 seconds. I'll be faster than Darrick. All right. Maybe. The answer is maybe. Classic lawyer style answer is maybe. That's because ADA cases are so fact specific. The key issue is not necessarily whether remote work must be granted, but whether the employer engaged in the interactive process and evaluated the request properly. I saw some comments of, we need more information, and that's exactly right. That likely was an ADA violation if the employer did not engage in the interactive process. I might have skipped over some facts. Maybe they did. They determined that there was an undue hardship in allowing that to happen, and they did not violate anything because they engaged in the interactive process to come to that determination. Okay. Another common compliance trap, I hinted at this earlier, is the use of 100% healed policies. These are policies that require employees to return to work with no medical restrictions whatsoever. Courts have consistently held that these policies can violate the ADA because the law requires employers to evaluate whether the employee could return to work with a reasonable accommodation. If it's a straight 100% healed policy, no medical restrictions allowed, that completely cuts out that interactive process, which, as we all now know, likely a violation. Next compliance trap, indefinite leave. Indefinite leave is another tricky area. Um, as Darrick mentioned at the beginning of the presentation, and I have alluded to a couple of times, the ADA may require employers to provide additional leave beyond FMLA leave as a reasonable accommodation. So scenario is, the employee has used 12 weeks of their leave under FMLA, but however, they need an additional 2 weeks of recovery. That may be required under the ADA as unpaid leave. However, there is a limit to that. Indefinite leave, meaning leave with no expected return date, is generally not considered a reasonable accommodation. So instead of that 2 additional weeks of leave that they need, they don't know. They need additional time to recover. Things went wrong in the surgery and they might be out for, they don't know. The key question is whether the employee's doctor can provide a reasonable estimate of when they will be able to return to work.
Kristin, I'll jump in real quick. Just two questions that came in most recently.
Mhm.
Um, Easy to answer, very lawyerly. Can you terminate someone who is already being investigated at the time they're going through the certification process under the FMLA? And does job performance come into play with the ADA? For example, if somebody needs supervision, is that a reason to require them to be at work? It depends. What can happen in these cases, and this is why we can't give definitive answers in this setting, is the court is going to look at whether there's some overlap between the employee's disability or serious health condition and their ability to do their job. So the employee might say, well, if I was given the time off that I needed, I would have been able to perform better. So just have to look at all the facts and be careful that you're not terminating someone for poor job performance that's tied to their disability or serious health condition. Sorry, go ahead, Krista.
That's quite all right. Next up, attendance. Another that we frequently see, attendance issues also frequently arise under the ADA. Next slide. Regular attendance can be considered an essential job function, especially in certain roles. But before terminating an employee for attendance problems related to a disability, employers must evaluate whether a reasonable accommodation, such as a schedule modification, intermittent leave, might address the issue. So as I've mentioned several times, one of the biggest compliance challenges that we see is the overlap between the ADA and the FMLA. Employers often think of these as like completely separate processes, but in reality, they frequently interact. One law may essentially hand off obligations to another. Um, a common example is when FMLA leave ends, but the employee still cannot return to work. At that point, the employer must consider whether the ADA requires additional accommodations, such as extended leave. Next slide, Darrick. So I have this next slide. Business people running a relay race, much like in a relay race where one runner hands off the baton to the next. Even once FMLA leave ends, if an individual needs additional leave or another accommodation, the ADA will come into play. Okay, last fact scenario for us. Maria used 12 weeks of FMLA leave after a surgery, but her doctor says she needs 4 additional weeks before returning to work. I realize that no one on this call would possibly have a policy that says this. However, the company that Maria works for has a policy stating that employees who cannot return to work after FMLA leave are automatically terminated. What should the employer do? 10 seconds. We're close on time. Automatically terminating the employee could create ADA liability. Even though the employee has exhausted FMLA leave, the employer still has an obligation to consider whether additional leave would be a reasonable accommodation under the ADA. It wasn't an indefinite period of time. They have the requirement to at least consider it. There may be reasons that it is not possible, but they do have the requirement to at least consider it and go through that interactive process. That evaluation must happen before any termination decision is made. So key takeaways, wrapping up the ADA portion, 3 main takeaways. First, most ADA claims arise from a failure to engage in the interactive process. Secondly, rigid policies, automatic termination policies, 100% healed policies often create liabilities. I see those all the time. Third, documentation and communication are critical. Employers should carefully document the interactive process and the reasoning behind accommodation decisions.
And Kristen, I know we're over time, but I
Yep.
think you almost answered
Yep.
the last 2 questions that came through. What is considered reasonable leave if an employee doesn't qualify for FMLA, and some employees are extending their leave and it becomes indefinite?
Mhm.
Again, the idea is you have to evaluate whether you can provide the leave as an accommodation, document it, the reasons why you cannot, if you determine that you cannot. And in terms of leave being indefinite, I'm hesitant to say that leave is indefinite unless you have a doctor's note saying we have no idea when the employee can return to work. So sometimes employers think the leave is indefinite because the employee said last week they'd be here this week, and this week they said they'll be here next week. Well, that's not indefinite leave. That's just change in circumstances based on the doctor's diagnosis. So back to you, Kristen.
That is everything that I have. Those are some great points. Thank you, Darrick. As he mentioned earlier, we tried to answer some of the questions as we could, but just too much content, too little time. So we will try and reach out to as many as we can and answer some of those questions personally. Um, and then if you 2 more slides, Darrick, and we have the SHRM and the HRCI activity ID codes. For anyone that needs those, we will leave those up for you. Other than that, thank you all so much for attending today. We really appreciate you being here. Otherwise, I think our webinar has concluded.
Thank you, everyone.